So this was a case that came to the Supreme Court because there were commercial fishers suing a federal agency who had interpreted its statute to allow the agency to place observers on the boats. So these would be individuals who would observe what the fishers were up to make sure there was not overfishing, and required these commercial fishers to pay for those observers. So they challenged that interpretation of the statute and went further to challenge what's called the Chevron, Chevron deference or Chevron rule, the Chevron ruling, which is a 1984 Supreme Court case that essentially said when there are ambiguous statutes or a statute is silent, requiring some interpretation to implement that statute, then the courts should use a two-step process. So it really became about, just to be clear, when a statute is ambiguous, who should interpret it? Should it be the agency or should it be the court? Is kind of the key question here.
That's what the agencies are for, to rely on their expertise. But that sent off some alarms of people saying, well, yes, but that could mean anything. You know, a government agency could kind of come in at any point in time and say, we're doing this for your safety and your security. So then they could do anything.
So I guess I would think of this way. You think about who's making the decisions. I think one thing we will see from this case is maybe increased variability in the interpretation of statutes. So if you think about the EPA, Republican administrations take a very different view towards what the EPA should be up to than Democratic administrations, right? And so we get some political instability there. And so I think part of what Loper does is, and if you look at Justice Kagan's dissent, she shows that there's work showing that Chevron results in more congruence across judges because they're looking at this reasonableness standard. So after removing Chevron, if courts are taking a view that has less deference to the agency, right, and therefore there's more room for judicial policy preferences to come in, you'll get a lot of variability. You could, depending on which judge hears a case. So I think that's the one concern there, is you get basically judges who are maybe not experts in a given policy area, who are going to then use their policy views to make a decision. And again, so I think it was just got more instability that already goes with our kind of political cycle based on which judges hear which cases.
So there was an article in Forbes, I think, where I'll just quote, where the Chevron versus the Natural Resource Defense Council, which had enormously, and this is an opinion, which had enormously and dangerously increased the powers of government agencies over time. Is that a fair statement?
It's a question of when the statute is ambiguous. I think we want to be careful to think about the scope here. Some statutes are clear, right? Sometimes it's unambiguous. So the question is, when a statute is ambiguous or unclear, do we want to defer to the agency or defer to the court? Right? Chevron deference did give agencies increased power, right? I don't know that I would go so far as to say, that it was dangerous. I think as long as you think Congress is writing statutes that provide appropriate levels of discretion and that the courts have this reasonableness check, right, that they're applying, that doesn't mean that agencies, can do whatever they want, right? They still have to operate within their statutory discretion, which Congress has the ability to write narrowly or broadly, as I said, right? Congress could say, keep the air clean, regulate pollutants in the air. They could say regulate this list of pollutants, right? So Congress has that ability to shape the discretion.